serves clients throughout Royal Oak and Oakland County and has extensive experience with estate planning, elder law, guardianships, conservatorships, patient advocacy, powers of attorney, trusts, wills, probate, and estate administration. He is a board member for the Area Agency on Aging 1B and the Senior and Caregiver Resource Network. He is also a member of the Alzheimer's Association Greater Michigan Chapter Wraparound Collaborative. We warmly welcome Attorney Collins and thank you for presenting with us today.
Well, thanks for having me. I appreciate the warm welcome. Boy, listening to LaToya, I mean, I always like listening to her because she's got so much great information, but it makes me both sad and angry that people take advantage. But I think that her information is so helpful to be cautious and aware. So thank you for the presentation, LaToya. Thank you for having me this afternoon to talk. My presentation intention is to think about planning in the midst of a pandemic for things that are happening actually outside of the pandemic world and have been happening for a long time, will continue to happen after the pandemic occurs. But I think that COVID has put a greater focus on areas like estate planning and what happens when a person grows incapacitated or when a person dies. So let's get started then. If you could switch to the next slide, please. I want to give us some context. As I say, the COVID crisis has brought into focus things that were going on previously but are now more intensely felt. And so I want to give you a notion of how estate planning sort of looks in the broader world. Caring.com does an annual survey of the general public in America about estate planning usage or lack of usage. And what they report is about 60% of Americans say that having a will or trust is very or somewhat important. However, even though we say that is a majority of us, 2 out of 3 adults still don't have a will. And so, you know, it's the age-old problem of knowing something is important to do, but not getting around to doing it, or not wanting to, or perhaps not having the financial means to get it done. Of the people who are 55 and older, only 44% of that group have estate planning documents in place. And so that is sort of challenging for that population. Obviously, as we grow older, the likelihood of us growing incapacitated or in fact dying is increased. And so not having estate planning documents in place leaves a significant gap in needed coverage and perhaps makes things much more complicated when those eventualities arise. If you turn to the next slide, please. So the other interesting thing that Caring.com survey showed was that 1 out of 3 people said that COVID had caused them to see a greater need for having an estate plan, but 31% of those people who saw a greater need still didn't do anything about it. And so you're left to wonder what's, you know, if people are looking at this and saying, well, we really should be doing something, but they don't take the action, what is causing that gap? I don't have a good answer for it. I mean, I think that as I said before, I think part of it is just finding people locked into old ways. In other words, if they don't expect to become incapacitated or don't really think they'll die anytime soon, so they don't start acting. Perhaps it is the isolation of our times where they don't get out like they used to. Although I'm here to tell you that many estate planning attorneys are meeting with clients remotely like we're doing here, talking to each other on Zoom and getting things set up. And in fact, there are ways to get things signed remotely without actually having to meet with an attorney in person. And again, it could be financial. Obviously, the pandemic has caused significant financial hardship to many people. And so someone who might recognize the importance of having a document set up, but just simply can't find the means to do it, or don't have the means to do it. Go ahead to the next slide. So I want to focus our attention on the kinds of things that happen when a person grows incapacitated, but doesn't have a written plan in place, or doesn't have an effective written plan. Because it is possible, even if you have a written plan, it's not effective enough to get the job done. And so there are two main outcomes in those cases. The first is guardianship, and a guardian is a court appointment of a person through the probate court who the guardian is given authority to act over a person's welfare, making sure that they have a place to live, making sure that they're fed and clothed, making sure their medical needs are met. That guardianship, and we'll talk a little bit more about how those get set up in a second, but the guardianship is intended to provide a person's general support of a non-financial component. Conservatorship, in contrast, is to deal with a person's financial affairs. So a person who has any sort of means, whether it's real estate or money in the bank or investments, and if that person grows incapacitated without a written plan, then the probate court is the place to go for that person's loved ones to get a conservator appointed to handle financial affairs for the incapacitated individual. Let's go to the next page, please. So I want to dig in just slightly about, and forgive me, I know that we only have about 40 minutes or so to talk here. So I unfortunately, this is a cursory overview of the whole discussion, but I want to at least highlight these things so you understand them in a basic way. And then if they apply to you in particular, then you'll obviously need to do some further investigating. The establishment of a guardian requires that the person be determined by the court to be legally incapacitated. And that means that they have some type of impairment that's defined by statute. Either it's mental illness, it could be physical illness, it could be because of their chronic use of drugs or intoxicating liquors, or some other cause. It could be temporary, so it could be someone had a stroke and is now unable to manage their own affairs, but will be recovering, hopefully. And then once they gain the recovery, then the guardianship will stop. Or it could be something ongoing. Think about someone who's developed dementia, and that's not going to be reversing. And so once the guardian is in place, that is likely to be in place until the person passes away. It has to be necessary to provide for the person's continuing care and supervision. There's going to be an evaluation of whether there's a less restrictive means. So if a person does have a written plan in place that is workable, then that might avoid the need for a guardian. But if someone doesn't have any written plan at all, then the guardianship could be the best kind of outcome to help a person be maintained. And this could include important medical decisions, including end-of-life decision-making. So, in COVID times, of course, we come across these great realities and hardships about the illness and the significant impacts. And hopefully with the spread of the vaccine and more people taking it, we'll have less and less deaths due to COVID. But the reality is right now, we're still seeing enough that in my office is still seeing people dying of COVID. So we need to have these guardianships in place when a person grows incapacitated. A guardian can be appointed on an emergency basis. Typically, the court process is a longer one, though, measured in several weeks, I should say, between the time the petition is filed and the hearing is held to have the appointment made. Let's talk about conservatorships for a second. If you go to the next slide. So a conservatorship is similar, as I said, to a guardianship, but this is dealing with the financial affairs. It requires that the individual be unable to manage their property or affairs. Again, similar incapacity issues, mental illness, physical illness, other disabilities, drug use, intoxication. And then it also has to show, and go to the next slide, please, that the person's monies will be wasted or dissipated without proper management of them. Or because they're not taking care of their own financial affairs, they need the support for care or welfare. The conservatorship also can be established by a person who is not necessarily incapacitated in the sense that they still are able to manage their own affairs, but they know that due to their age or infirmity that they're unable to manage their own affairs effectively, and that they would benefit from having someone else serve in the role as conservator to help them out, to be able to manage their financial affairs. Those are more unusual, but they happen. And you know, I see them come into my office in circumstances where someone has, well, in great numbers, in the majority of the numbers of cases, where they have had bouts of mental illness over time, and have finally come to the realization that having someone help them with their financial affairs makes a lot of sense. I'm thinking about a person suffering from manic depression, where in their manic phase, they spend uncontrollably, but they've come to realize that that manic approach leaves them open to improper spending. And so by having a conservator, that can be limited or stopped altogether. All right, let's go to the next slide, please. So guardianship and conservatorship are the outcomes when a person hasn't done written planning in advance of their incapacity. But I'd like to have us, because the people on this call obviously are proactive, you're taking advantage of learning to consider things. Having a written plan could avoid the need for a guardianship or conservatorship in many cases. And so I want to focus our attention next on three types of plan or types of documents that can help avoid the need for guardian and conservatorship upon incapacity. The first that we'll look at is a financial power of attorney. The second is a patient advocate designation. And I also want to spend a few minutes talking about a Hipaa release. And we'll talk about what that is and what it does. All right, so let's look first at a financial power of attorney. What this does is it's a document, a drafted document that allows a person to name someone else to act as an agent on their behalf. The good part about the financial power of attorney, it does not require court involvement to get set up. The person who is the principal, the person setting up the document, names the agent. The person who is named as the agent, the official title for that position is called attorney in fact. Now, the person does not need to be an attorney to serve as the agent. So, the problem in law is that we're stuck with names of things that were previously set in place. So unfortunately, they weren't marketing people when they set these things up. So it's calling it the attorney in fact is the name of the position, but it does not, as I said, have to be an attorney to do it. Most times it's someone like a spouse or a child or a very close friend who's reliable. Those are the most typical agents who are named. It's important to name someone, obviously, who has your trust, because they're going to be doing important work for you on your behalf, and they need to be trusted to do the work correctly and in your interest. Powers of attorney can be effective either when they're signed at the time of the signing or upon incapacity. So most powers of attorney that I draft, I like to have them effective immediately. Most of my clients end up naming spouses or children, so they're usually acting with these people anyhow before they sign the document in my office. But the reality of it is that they're naming someone that they trust, and so having immediate ability to act is useful and important. Having it as a springing power effective only upon incapacity can prove complicated depending on the incapacity that the person is facing. A springing power would only come into effect to be used if the triggering event occurred. And the triggering event typically would be some sort of doctor review of the person who was the principal, saying that that person was no longer able to manage their own affairs, such that they needed the agent to start acting. In some instances, that's pretty easy to figure out, right? A person has a stroke and isn't able to answer questions or to read or write, because of their illness, then that's pretty clear. They're incapacitated and the agent should start acting. Think about a dementia case, though. I mean, unfortunately, with that illness, it is not always apparent when the person has grown so far incapacitated, springing power should start. And some doctors are reluctant to write that letter before the person is fully far along, but the individual is starting to make bad decisions for themselves or not acting properly, not paying bills, right? Things are just stacking up. And we see that a lot, where the person has started to just ignore things because of their oncoming illness, but the agent still doesn't have authority. And unfortunately, in those kind of cases, what we end up doing is going into the probate court and asking for a conservator to be appointed. So that's a long way to say that I think that there's a lot of benefit for having an immediately effective financial power of attorney. The language that is also used that is sometimes confusing to people is that these are called durable powers of attorney. And let's talk about what durability means. So that's a technical term which describes that the document is effective and it stays in effect even though a person is grown incapacitated. That's the durable part. It's durable through the illness. Powers of attorney can be canceled by the person who's created them at any point, as long as they have the capacity to do so. If they never cancel the power of attorney, then that document will stay in effect until the person passes away and dies. And at that moment, then the power stops. And a lot of times fiduciaries, the agents are not aware of that and will continue to act, but that's not appropriate. It's, once a power of attorney principle has died, then that power stops with them. Let's move on to the next slide, please. So let's talk about the kind of powers that a power of attorney grants. The biggest ones that most people are looking for are banking powers. So dealing with banks, Social Security, pension, taxes, the kind of day-to-day things, being able to write a check, being able to access the bank account and learn about the balance in the accounts, or who's put money in or who's taken money out. Dealing with litigation, dealing with care issues. So it could be signing a care contract. That's an important element of what powers of attorney agents can do. Includes more extraordinary powers, like powers to make gifts or to create or amend trusts. Now, interesting, in Michigan, you can't grant someone else the power to create a will for you, but you can grant the power to someone else to make a trust on your behalf. So those powers can be really useful to manage and preserve assets, or it could be useful if you have assets to potentially use a newly created trust to help qualify for need-based benefits like Medicaid for long-term care and things like that. All right, let's move ahead. So I want to focus our attention next on a patient advocate designation. So in Michigan, we offer what's called a patient advocate designation to allow the patient to appoint someone else, the agent, in this case called the patient advocate, to make medical decisions on behalf of the patient if the patient has grown incapacitated and can't make those decisions for him or herself. So the patient advocate designation deals with applying or withholding medication, medical treatment, deals with end-of-life decision-making. It crosses over into what people typically think about as living wills. Again, on a technical level in Michigan, we don't have a statute that directs living wills, but many practitioners will, in the patient advocate designations that I see, like the Michigan Hospital Association form, include living will concepts. So the living will concepts being how end-of-life should be dealt with. The patient advocate is to look to the document to determine what power is granted and then comply with it. The patient's wishes are the ones that should be carried out. The advantage of having a patient advocate designation is it does not require probate court involvement to either set up the document or to utilize it. Now, the patient advocate designation is a springing document. It's only effective upon incapacity. Go to the next slide, please. So the incapacity determination is made by two licensed professionals. The statute specifically spells out the person's physician and or another physician or a psychologist. So two people two medical professionals need to make the determination in writing that the person is grown incapacitated such that they can't make their own medical decisions. And if that evaluation has been conducted and determined that the person isn't in fact incapacitated, then the patient advocate would start acting. The person, if they have religious objections to an examination, need to specifically set that out in the designation itself. So it needs to be clear in the document if that is in fact something that's applicable. It is also important to have an eye towards Hipaa in the patient advocate designation. So Hipaa, I guess we'll pick it up here because I don't know if I specifically describe it in the slides. Hipaa is a health privacy law that has been around for decades at this point, and it limits who has authority to learn about your medical condition. We go to doctors all the time and they have us fill out a Hipaa release. And if you read those releases, and I happen to because I'm an attorney and I like to read that sort of stuff, when you read them, most of the time it says, I give authority to release information to other doctors or hospitals or insurance companies, but it fails to remember that we have family or friends who might want to learn about our condition. And so having a standalone Hipaa release is important, especially one that specifically addresses the fact that we want our medical information to be shared with our loved ones. It's not technically a power of attorney, but having that standalone release is really a useful tool, especially in medical emergencies, to be able to have people learn about what's going on with you. I also, in my drafting, include Hipaa release language in the patient advocate designation itself, as well as in my financial power of attorney, because sometimes there's a crossover between medical stuff and financial stuff, so that the medical information or access to medical information will be important as part of the financial power of attorney's activities. A lot of times, by the way, people will name the same agents for both of these kind of documents. So you'll name the same agent for both your financial decision-making and your medical decision-making. And that makes a lot of sense, right? I mean, if you have a spouse, most of us look to our spouses to help in those situations. And so to name them as the agent across those decision-making places makes a lot of sense. All right, let's move to the next slide, please. So, I get questions a lot about who to name as a patient advocate. And obviously the top priority is it has to be someone you trust. As I said, most typically it's a spouse, child, or a friend. Although I can tell you, I just reviewed an estate plan with a client who did not want to name her spouse as her patient advocate because she told me that the person, her spouse, would not make the kind of decisions or could not make the kind of decisions that would be necessary if she named him as her patient advocate. So it's not required that it be your spouse and your children. It could be other people altogether, but it's important to have. Can you name more than one person as a patient advocate? The answer is, like a good lawyer, it depends, or maybe. What do I mean by that? Well, so there's some difference of opinion among lawyers. And I don't believe that there's been a Court of Appeals or Supreme Court in Michigan decision on this topic. The statute itself references a patient advocate, which would suggest that it would be one person at a time. There's commentary on the statute, though, that suggests that you could name more than one person at a time. So, my general practice is to suggest my clients really name one person at a time, as opposed to naming two or more at the same time. I also remind folks who might want to name more than one agent at a time that it's complicated if you do that. I remind people it's like running a three-legged race, the kind of race where they take two people, tie their close legs together, and then they make them run from here to there. And some people are really successful in making the journey from one end of the thing to the other, but others fall down or never make it all the way across. And it's the same kind of thing when you name multiple agents at the same time. If they get along well and can make a common decision, terrific. But if they are fighting or disagreeing or whatever, then the decision might not get made in a timely way, or it might not get made at all, or they might end up in court fighting about it, which obviously is not desirable. So a word of caution about naming more than one agent. All right, let's move to the next slide, please. So I want us to next focus, we've talked about sort of the importance of doing planning for incapacity. We've also talked about what happens if you don't plan for incapacity. I want us to next focus on death and dying and the planning in the situation where a person has died but doesn't have a written plan in place. And as you know from the very beginning of my talk, the great majority of us don't have a written plan at all. So this will talk to the great majority of people. My hope, by the way, in talking about this talk is that I will convince and entice you to actually do your planning if you haven't already, or if you have, then it's probably time to review it. So dying without a written plan. What happens is that the laws in Michigan provide a mechanism for distributing a person's assets who's died without any will in place at all. There is the laws of intestate succession. Technically, intestacy means dying without a will. And there's a statutory priority that's out there then that describes who takes what out of the estate. For many people, that will be fine. It'll match exactly what they would have otherwise wanted in writing. But for some, it will not match at all because they have an unusual family circumstance or a different intent. But unfortunately, if they never took the time to put things in writing, then it doesn't matter whether they had an intent or not. Spouse is given the highest preference and benefit from intestate distributions. And then children and grandchildren are included if there isn't a spouse, or if there's a blended family, then it gets a little more complicated. And I'm not going to go into the details of that necessarily, except to say that the law will figure out who the heirs are and determine, based on the laws of intestate succession, who will take. So who are your heirs? If you're married, your spouse is your primary heir. If you have children and no spouse, then those children. If you have children, but they've died, leaving children of their own, your grandchildren, those grandchildren would take. If you don't have spouse or children or grandchildren, then the law looks to see, do you have surviving parents? If not, siblings, then nieces or nephews. If none of those people exist, then the law says look to see if you have grandparents on the maternal and paternal side. And then if you don't have those folks, do you have aunts or uncles? Do you have cousins? It is not unusual in a situation, or it can be, these are more unusual, I guess I should probably restate that. It's unusual to have this sort of case, but it is possible in a situation where you don't have a written estate plan and then the person dies, and then there are people who may have never met this deceased person who's now receiving a share of an estate. Think about remote and distant cousins who might still be included in the distribution, but again, would never have had contact with the person who had died. So it's not desirable in that sort of case. But for many people, it won't matter because their spouse is alive, and so the spouse will take the entirety of the estate, or their children are alive, and so they'll split it up. Let's move ahead to the next slide. Even with an unwritten plan, there are some assets that will go and pass outside of probate. And those assets include jointly held assets. So if you have a joint bank account with someone else, or jointly held real estate, think about spouses holding a house together, then those assets, when the first spouse dies, will pass to the survivor, and there's no probate for that transfer. Think about beneficiary designated assets like insurance policies or IRAs or 401ks, 403B, 457s, any of those kind of deferred assets. If there's a beneficiary designated, then that designation will control and allow those assets to pass. Those transfers are not going to require probate court involvement in the great majority of cases. Now, if people are fighting, then that kind of asset could end up in the probate court for the judge to look at and decide. But again, most cases are uncontested, and so those designations or jointly held assets will pass outside of probate. Go ahead to the next slide, please. So if you have a written plan, if you have a will in place, then the will control assets that are in your name only, without a joint donor, without a beneficiary. Those assets, in order to pass, will go through the probate process after your death has occurred. The will allow you to describe who's going to be in charge of that administration, so it allows you to name the personal representative. The personal representative is the name for the person who administers the estate. It used to be called executor, but it hasn't been called that for a long time. So you'll sound all modern if you call it personal representative. If your intention is to disinherit someone, then having a written estate plan is a must. Think about that circumstance where you have a child who you don't want to leave a share to. You'll need to say that specifically in the will to make sure that that child does not receive. If you're charitably inclined, if you wanted to leave a gift to charity, you need to spell it out so that that can be affected when your death occurs. As you probably heard, or as you didn't hear me say when I was going through the list of heirs, charity is not part of that. So if you are intending a portion of your estate to go to charity, then it has to be somewhere in writing. And that could obviously be as a beneficiary on an insurance policy or a 401k or IRA, or it could be as a beneficiary of a bank account, for example. But typically, if people are going to leave a gift up through their estate, they're going to want it in writing and do that through like their will. Let's go to the next page. The benefits of having a will are that they're relatively simple to establish and maintain. And as I said, you get to name your personal representative. Let's move ahead, please. Oh, and you know what? I didn't put a slide of this together, but I guess I should spend a couple minutes talking about probate because I get a lot of questions about this usually. So let's talk about what the probate process is in a general way after a person dies. And this will help, fill in the picture for you a bit. When a person passes and they have assets in their name alone, without a joint donor, without a beneficiary, those are probate assets. And those assets, in order to pass, will have to have an estate opened at the probate court, have a personal representative appointed. The personal representative will be appointed through one of two main processes. Either there will be papers filed with the court and a petition setting a hearing date, and the court will then hear the case to admit the will and determine who the personal representative should be. That's more unusual. The more typical process is that an application is filed and an informal process is made where the proper papers are filed with the court and there is no specific hearing. If the papers are all filed in an order, then the court will issue what's called letters of authority. And those letters of authority give the personal representative the authority to act over the estate. The great majority of estates that get open informally by this application process. Now, one of the problems in the time of COVID is that the courts are all closed. Like you can't walk into them. And so the processing times have increased significantly, unfortunately. What that means, in Wayne County, it could be about a month before you get the papers processed and back. It could be longer than that even to get your hearing if you're going to set up for a hearing. So once the estate opens, though, the personal representative is given authority to act over the estate. They'll give notice to creditors that the estate exists. Creditors will have typically 4 months to make their claim, and they'll be dealt with if they come forward. And if they don't, then they won't be considered and won't be paid. The persons who died, that person's tax returns will have to be completed. And then the assets will be distributed under the terms of the will, if there is a will, or under intestate succession, if there is no will. The typical estate process through the probate courts takes somewhere between 8 months to a year. And a lot of that time is waiting for the creditor claim period, that 4-month period. It's not going to take much less than 6 months in any event. And it also will depend on when the taxes, when the person dies in the year, because their taxes will need to be prepared, right? So if you think about a person who dies in December, Their tax information will come January, February, March, and those returns will be able to be filed in April, and so we'll be able to close that estate out fairly quickly, assuming everything else is dealt with. Think about the person who dies in January. We're going to have to wait till the following year to get their tax returns in order. Let's talk about a trust for just a second. And I know I'm coming to my end of my time, so I don't want to linger too long here. A trust is another written planning option that can be a valuable approach to setting up an estate plan. And what it does is it gives you the ability to set up an entity, a trust. It's a contract, it's a pile of paper that allows you to nominate someone to serve as the trustee and manage the affairs of the trust. The trust, and the kind of trust I'm thinking about here, is a revocable trust, a revocable living trust. It gets set up while you're alive. You'll typically name yourself or yourself and your spouse as the co-trustees of the trust to manage it while you're alive. Upon the death of the first of the trustees, then the survivor will continue to act. On the death of the second or the remaining or sole trustee, then a successor would be named. The advantage, one of the advantages of having a trust like that is that it doesn't require probate court involvement in many instances. And so the administration while you're alive, if you've grown incapacitated, will happen without having to go into court for that guardian or conservatorship. And the advantage at your death is that the primary administration of a trust is generally not happening through a probate court. And so the administration is a bit, it can be easier. It doesn't have to be, because sometimes it's complicated, but it can be easier in a lot of instances. The trust will still need to deal with creditor claims and taxes and all that after a person has died. But as I said, it will generally be a little bit of a smoother proposition for the administration itself. Trust can also be used in situations where a person has an inheritance taxable estate. Now, these days, the inheritance tax exemption is well over $11 million. So if a person dies with less than $11 million, there's not going to be inheritance tax to pay on that estate. But if they have an estate that's over $11 million, then it may be worth doing some special planning to minimize or eliminate that tax burden. Let's go to the next slide, please. As I said, the trust is a little bit more complicated to set up and maintain, but it has some advantages. As I said, these are transition, I should say, upon disability or death of the person who's created the trust. But there is still administration. Let's go to the next slide. So as I wrap up and conclude here, I would urge you to take some action, to do something in response to hearing this talk. And what I'm thinking about is, to the person who has no written plan in place, that I hope this spurs you to explore getting a written plan. The benefits of it are substantial, and as I've hopefully described, the downsides of not having a written plan can be pretty significant. What I recommend is that people who have a written plan pull them out and review them, and typically on an annual basis, making sure that the person who you've named as your agents and the fiduciaries and the fiduciary role are still the right people, and that the distribution that you've intended, that you currently intend, matches what you drafted into the document. And to the extent that any of that's changed, that you make updates for doing this. One last thing, though, is a word of caution, which is about doing this yourself. Now, you know, one of the great benefits of the internet is that there are a lot of documents available, legal documents available for download pretty simply. That's good on some level, but it's also a trap. And what I mean by that is that, and this is true even about filling out a form that you might buy at a store, because those forms exist, and I'm not saying that they don't serve some purpose, but what they do is they offer an opportunity to do things for yourself where you might not be aware of the implications of what you're doing. You might fill things out improperly. And I'm here to tell you that in my experience, the cost of setting an estate plan up properly on the front side is often dwarfed by the cost of fixing something that's been messed up after a person has grown incapacitated or has died. And so I offer a word of caution about doing it for yourself. As I like to say, not many of us change our own oil. Not many of us cut our own hair. We want to make sure that we're not doing lawyering on ourselves, especially if it's your first time, right? It's a trap. So, there are really good resources out there, but be careful when you use them, or if you do. Seeking the advice of a sage attorney to help draft these is a really good thing to do. All right, if you go to the next slide, this is my contact information. If this talk has generated questions that you would like to ask in the chat, by all means, I'm happy to answer questions right now. If you prefer to contact me privately to ask questions or whatever, here's my information, and please do feel free to call me at my office. I know there's some folks on the phone who might not be seeing the slide, so my phone number is 248-545-2500, and I will look forward to speaking with you then. With that, I'm going to stop, and I will take any questions that this might have driven.
All right, we have one question here. What's the usual cost of creating a power of attorney, and what are some of the steps that we would want to follow?
Sure. So I'm going to answer those in reverse order. So let's talk about the steps, and we'll talk about the cost. So in terms of the process for planning, the way I approach it is I like to send a questionnaire out to my clients. The questionnaire is going to ask them to gather information about themselves, about the assets they hold, what their intention is, like who's going to serve in which role as power of attorney agent, and in which order. And then once we've confirmed that information, then the drafting is pretty straightforward. Powers of attorney are relatively easy to set up, which means that they're somewhat more cost effective, to be blunt, than setting up a will or a trust. So to get to the cost answer, and I'll be careful here to say it depends. I mean, attorneys are all different and they charge different rates. So I know that there are some attorneys who will draft a power of attorney for a flat fee and charge a limited amount of money. It could be, some attorneys can be under $100 for a power of attorney. Others can be a few $100s. Not all powers of attorney are the same, as we've sort of described in the talk here. So you have to be careful, and specialization of knowing what to do is important. So, powers of attorney, themselves can be relatively inexpensive to set up. For a medical power of attorney, there are forms available through the Michigan Hospital Association that you don't necessarily need to have an attorney at all. It's a fill-in form, and that you can perhaps do yourself. However, I offer the same caution that I did at the very end with that last slide, which is be careful about filling those out, because even with a patient advocate designation, you can mix things up. And there you're dealing with end-of-life decisions. So if you mess it up, it is with a substantial potential cost. I can tell you one of the most expensive cases that came into my office over the course of the years is a situation where a person filled out one of those hospital association forms, but on top of it, wrote in the document what ended up being contested as a will. And after tens of thousands of dollars of litigation, we finally figured out what that actually meant, because it was a mess. So hopefully that answers in a way that's good enough. And if you want to talk about my fees specifically, I'm happy to talk about it, but not on this call, but contact me and I'm happy to discuss that. Any other questions that I might address?
No, I am not seeing anything in the box. If anybody else has questions, again, please use the chat or the Q&A function here. We do have a few thank yous for the wonderful information, so we appreciate that. Vanessa, I think I'm gonna send it off to you. I think we've hit our time here.
Thank you so much. So a big thanks to both of our speakers today for such wonderful presentations, and thank you to everyone that has joined our Lunch and Learn. Today's presentation has been recorded, and we will upload all of our Lunch and Learn recordings to our website. So if you want to share this recording with anyone, please do so. You'll be able to do that from our website. If there's anyone with us that's not currently a member of the Healthier Black Elders Center program and would like to join, we can sign you up over the phone. You can call our office at 313-664-2616. So thanks again to everyone. Please stay safe. And our next Lunch and Learn will be in April on Wednesday, April 21st, and it will be with a podiatrist as our speaker. So thanks again. Take care, everyone.